We have a developing story for you now from the U.S. Supreme Court. Today, the High Court struck down affirmative action programs at two schools, Harvard and the University of North Carolina at Chapel Hill, UNC. The court ruled both programs violate the Equal Protection Clause of the Constitution and are therefore unlawful. Well, this afternoon, President Joe Biden responded to the ruling, saying he strongly disagrees with it.
What I propose for consideration is a new standard, where colleges take into account the adversity a student has overcome when selecting among qualified applicants.
Well, our 3 News legal analyst Stephanie Haney joining us tonight. So let's start, first of all, with this. What were Harvard and UNC doing that caused this ruling, or that it certainly even made them look at it?
Sure. So the process that they were using has been called race-conscious admissions programs, and this is considering race of all applicants in order to raise the number of Black, Hispanic, and other underrepresented minority students in their classes. So what this ruling did is it overturned the 2003 ruling Grutter versus Bollinger. That's where the court said race could be considered as a factor in the admissions process. And it was because universities had a compelling interest in maintaining diverse campuses. Now, of course, others before had touched on the issue as well. So today's ruling, Christy, once again goes against decades of precedent, which is something we've seen this court do before.
Right. I think a lot of people are looking at this and they're saying, what does this mean for all of the other schools? Because this was only 2 schools that were impacted initially by this, but let's look long term.
That were the subject of this case. Yes,
right.
Absolutely. And Chief Justice John Roberts wrote the majority opinion here and left open the possibility of colleges considering discussing race in an individual student's application. Like perhaps, for example, if a student encountered racial discrimination and shared that in their application. In the opinion, he had said any discussion must be tied to that person's character or a unique ability that person can bring to a school. Now, Harvard and UNC Law, by the way, my alma mater, they're just 2 institutions with admissions policies that were taking race into account. Schools with extremely competitive admissions programs will be the most affected. These schools predict that this ruling will lead to a significant drop in the enrollment of minority students and require admissions officers to experiment with new race-neutral plans that are intended to counteract that impact. But NBC News has looked at admissions practices across the country, and they report that the vast majority of colleges accept almost all applicants. So for those institutions, they expect not to be incredibly affected.
Impacted that much. Okay. What are we hearing from the justices tonight? Because there were 3 dissents here.
There were, yes, multiple dissents. Of course, not everyone was on the same page, and the opinions on either side of this ruling have strong words. So in his concurring opinion, the second Black Supreme Court Justice Clarence Thomas said 2 discriminatory wrongs cannot make a right, and affirmative action had to end because he said, quote, the racial boxes into which universities place applicants are little more than stereotypes. Justice Ketanji Brown Jackson, the first Black woman to serve on the court, wrote in a dissenting opinion that the ruling was truly a tragedy for all of us. And Associate Justice Sonia Sotomayor, the first Hispanic justice, wrote that the court stands in the way and rolls back decades of precedent and momentous progress. So as you can see, the justices wrote very passionately about this issue on both sides, Christy.
No doubt. And I'm sure we'll be talking about it for a while. Stephanie, we appreciate your expertise here. Thank you.
No problem.